Hello, dear students. I am Dr. Vibha Sharma, Associate Professor in Government Law College, Ajmer. As you can see, that in this video, we would be looking into some of the important aspects of parole under the subject of penology. Starting from the introduction, that is the origin of the word parole, as well as some of the historical background of the grant of parole, we will go on to see the meaning and then the definition of some of the jurists to have an idea about the role that parole has in the life of a convict. Thereafter, we would also take into account some of the observations of the Supreme Court in relation to parole made in its judgments. Thereafter, we will move on to see the legal status of parole in India and then the circumstances when it can be given along with the general rule relating to parole. And finally, we will see the objective as to what parole actually intends to achieve. So let's begin with the understanding of parole. Word parole is derived from the French "je te donne la parole." This is how it is somewhat pronounced. It actually means I give my word, that is the word of honor. This word was used by the prisoners of war for their release by giving promise to the captor. Historically, parole is a concept known to military law and denotes release of a prisoner of war on promise to return. Here it would be interesting to note some more about its origin, as some of the jurists say that the idea of parole was introduced in 1840 by Alexander Maconochie, a Scottish geographer and captain in the Royal Navy. He was appointed as superintendent of British penal colonies. Instead of necessitating the prisoners to serve their sentence hopelessly until full sentence had been served, he aimed to punish the prisoners for the deed committed and to train them for the future. He developed a plan and divided it into three grade system. The first and second grade group was mainly for the promotions earned through good behavior, study, and labor. The third grade consisted of obtaining conditional liberty outside the prison while obeying rules. Now, on violation of such rules, the prisoner would return back to prison and would start all over again, the rank of three-grade process. The ticket to the leave system was reformed, and this led to what many consider as world's first parole system. The prisoners who were served indeterminate sentences, that is, open-ended sentences, could now be released if they show evidences of reforming and rehabilitation. Through participation in the grade system, which was based on the unit of marks, ensured they earned marks for their good behavior and lost marks on their bad behavior, and could spend them on passage to higher classification statuses, ultimately conveying freedom. This thought was based on the ideology that a sentence should not be a mere arbitrary sentence, but a source for reformation and the greed to return back to the society. Francis Lieber's thoughts on parole later reappeared in the Hague Convention, Declaration of Brussels of 1874, and the Geneva Convention relative to the treatment of prisoners of war. In 1847, parole was first coined in a correctional context by Samuel G. Ho, a Boston penal reformer. After knowing about its origin somewhat, let's figure out What does it mean? Concise Oxford Dictionary says that parole means release of a prisoner temporarily for a special purpose or completely before the expiry of a sentence on the promise of good behavior. Such a promise, a word of honor. Black's Law Dictionary says parole means release from jail, prison, or other confinement after actually serving part of sentence. It also says that it is conditional release from imprisonment which entitles the parolee to serve remainder of his term outside of an institution if he satisfactorily complies with all terms and conditions provided in the parole order. After seeing some of the meanings of the word parole, we would now see as to how some of the renowned jurists have defined parole. Starting from J.L. Gillen, we find that he says parole is the release from a penal or reformative institution of an offender who remains under the control of correctional authorities in an attempt to find out whether he is fit to live in the free society without supervision. Then we find that one of the renowned criminologists, Donald Taft, has defined parole as it is a release from prison after part of the sentence has been served. The prisoner still remaining in custody and under stated conditions until discharged and liable to return to the institution for violation of any of these conditions. Then we find that Dr. Sutherland says that parole is the liberation of an inmate from prison or a correctional institution on condition that his original penalty shall revive if those conditions of liberation are violated. And then, of course, Sir Rupert Cross says that it is the release of a very long-term prisoner from a penal or correctional institution after he has served a part of his sentence under the continuous custody of the state and under conditions that permit his incarceration in the event of misbehavior. So we find that there are very many common factors that have been indicated by these jurists as far as parole is concerned. After seeing the definitions as given by some of the renowned jurists, we now will see the important observations made by the Supreme Court of India. In the case of Dadu Tulsidas versus State of Maharashtra in the year 2000, the Honorable Supreme Court said that parole means the release of a prisoner temporarily for a special purpose before the expiry of a sentence on the promise of good behavior and return to jail. It further observed that it is a release from jail, prison or other internment after actually being in jail serving part of sentence. And they clarified that it is not suspension, remission, or commutation of sentence. Convict continues to be serving the sentence despite grant of parole. Again, in Sunil Fulchand Shah versus Union of India, the court said, in India, there are no statutory provisions dealing with the question of grant of parole. However, by administrative instructions, rules have been framed in various states regulating the grant of parole. Thus, the action of grant of parole is, generally speaking, an administrative action. And then it further observed that parole is a form of temporary release from custody which does not suspend the sentence or the period of detention, but provides conditional release from custody and changes the mode of undergoing sentence. Then we find that in the year 1987 itself, the Supreme Court, in the case of Poonam Lata versus Vadhavan, had categorically stated that parole is an act of grace, not a matter of right. It is a provisional release from confinement, but is deemed to be a part of the imprisonment. They said release on parole is a part of the reformative process and is expected to provide opportunities for the prisoner to transform himself into a useful citizen. And then they further observed that parole is thus grant of partial liberty or lessening of restrictions to prisoner, but release on parole does not in any way change the status of prisoner. Okay? So stating simply, parole is the premature conditional temporary release of a prisoner on the terms of abiding by the conditions along with the observance of certain restrictions to avail the privilege of returning back to the society and socialize with family and friends, keeping in mind correctional theory and preparing to return back to his or her social life. During parole period, there is no suspension of sentence, as was stated by the Honorable Supreme Court in the case of State of Haryana versus Nauratta Singh in the year 2000, when it pronounced that during parole period, there is no suspension of sentence, but the sentence is actually continuing to run during that period also. And then, of course, if the paroled prisoners violate the conditions on which they are released, they may be returned back to the prison. Okay? Now coming to the legal status of parole in India, we are aware that in India, prison reforms did not emerge out of the social movement, but were necessarily an outcome of the worst conditions of treatment faced by the political sufferers in prisons during the period of their imprisonment. They repeatedly lodged protests with the prison authorities and made all possible efforts to see that the rigors of prison life are mitigated and prisoners are humanely treated. However, in the meantime, the reformative trend, which was gaining momentum in the field of penology all around the world, also gave fillip to the cause of correctional method of treatment of offenders in India. It was realized that confining convicts in closed prison cells hardly serves any useful purpose. The overall effect of these changes brought about significant reforms in prison administration in India during the later half of the 20th century. But there has always been a lack of planned penal program in this country. So we find that the grant of parole in India is governed by the rules made under Prison Act of 1894 and 1900. Many state governments have formulated guidelines to bring out objectivity and facilitate decision making to determine whether parole needs to be granted in a particular case or not. Such decisions are taken in accordance with guidelines framed from time to time. And realistically speaking, it was not until the Supreme Court and many high courts of India actually came up with the aspect covering parole. We know that the grant of parole is an administrative or an executive function. Generally, either the regular parole will be granted or an emergency parole will be granted, about which we will know in the next slide. These are some of the circumstances in which the regular parole is granted. Since it is an executive function, therefore, we must know that generally the procedure adopted for the grant of parole is that the prisoner either on an application made by him, his relatives, friends, or his legal advisor may apply for the grant of parole, and such a prisoner who desires to be released on parole ordinarily submits an application to the superintendent of prison, who endorses his remarks thereon and submit one copy to the competent authority, who finally grants the parole to the prisoner along with the nominal roll of the prisoner, and the other copy is sent to the district superintendent of police of the district in which the prisoner proposes to spend his parole period. Now, thereafter, that district superintendent of police to whom it has been sent will immediately make inquiries to ascertain whether the ground or grounds on which parole is applied for are genuine, and thereafter he submits his report immediately to the competent authority, inter alia mentioning whether it recommends the grant of parole and also whether there is a likelihood of breach of peace if the prisoner is released on parole. On receipt of an application for parole, the competent authority generally makes such inquiries as it considers necessary and pass appropriate orders which it thinks fit. Generally speaking, the competent authority grants parole subject to his or her executing a surety bond and a personal bond to observe all or any of the conditions mentioned in the order, and subject to such other conditions which may be specified by the competent authority. It is to be noted that when a prisoner convicted of serious offence is released on parole, a condition shall be included in the parole order directing or requiring the prisoner to report at the police station under whose jurisdiction the prisoner resides during the parole. Generally speaking, these are the circumstances when a regular parole may be granted to the prisoner. And that is, all prisoner eligible for furlough shall be eligible for regular parole for the following reasons. Delivery of child by wife, except high security risk prisoners. Generally, they are not given this kind of a parole. Serious illness of father or mother or spouse or son or daughter. In case of natural calamities such as flood, house collapse, earthquake, fire, etc., or to pursue the filing of special leave petition before the Supreme Court against a judgment delivered by the High Court convicting or upholding the conviction, as the case may be. So generally, these are the circumstances when a regular parole is granted to the prisoner. Now, coming to the circumstances in which the emergency parole or custody parole may be granted. Generally speaking, all convicted persons may be eligible for emergency parole for reasons like death or marriage of the close relatives. However, generally it is also to be noted that no extension can be granted to emergency parole. Now, the authority approving emergency parole shall decide whether to grant parole under police escort or with a condition to report daily to the local police station, depending upon the crime committed by the prisoner and his conduct during the stay. There is a general rule which is applicable to both regular as well as emergency parole, and that is that a prisoner shall not be released on regular or emergency parole for a period of 1 year after the expiry of his last emergency or regular parole, except in case of death of his nearest relatives. Okay. So these are general guidelines which are being followed by the competent authorities while granting parole to the inmates. So now, of course, it is very easy for us to figure out the object of parole. Undoubtedly, it is a penal device which seeks to humanize prison justice, to enable the inmate to maintain continuity with his family life and deal with family matters, to save the inmate from the evil effects of continuous prison life, to enable him or her to retain and develop self-confidence, as well as to develop constructive hope and active interest in life. So we can very well say that the system of parole aims at meeting the ends of justice in two ways. How? It serves as an effective punishment by itself, in as much as the parolee is deterred from repeating crime due to threat of his return to prison or a similar institution if he or she violates parole conditions, and it serves as an efficient measure of safety and treatment reaction to crime by affording a series of opportunities to the parolee to prepare himself for an upright life in society. So then it becomes very obvious that the ultimate significance of parole lies in the fact that it enables the prisoner a free social life, yet retaining some effective control over him. Every prisoner is carefully watched, and one who shows potentiality for correction and responds favorably to the disciplined life inside the prison is generally allowed considerable liberty and finally released to join the society conditionally. Thus, parole is essentially an individualized method of treatment of offenders and envisages a final stage of adjustment of the incarcerated prisoner to the community. So now we come to the end of this particular video. I hope that all those things that I have shared in this video about parole are very clear to all of you. Hope you all are taking very good care of yourselves as always. So please read well, study well, do well, help your family, help yourself, take very good care of yourselves, and God bless all of you. Best of luck. Thank you.